An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. The Substantial Effects Doctrine, NLRB versus Jones and Laughlin Steel, 1937, United States versus Darby, 1941, and Wickard versus FIlburn, 1942.
Commerce Clause gives Congress the power to regulate interstate commerce, which includes the power to prohibit such commerce. However, the Supreme Court has ruled that the Commerce Clause, working in conjunction with the Necessary and Proper Clause, also allows Congress to regulate certain types of intrastate activity. That is, activity that is not among or between the several states. Over the decades, the Supreme Court has adopted different tests to determine what kind of intrastate activity Congress can regulate. During the Progressive Era, the Court applied the so-called direct effect test. In E.C. Knight, in 1895, Hammer v. Dagenhart, in 1918, and Schechter Poultry in 1935, the Court held that Congress could only regulate local activity that had a direct effect on interstate commerce. However, after 1937, the New Deal Court replaced the direct effect test with the new substantial effect test. In 3 decisions that are still good law, the Court held that Congress can regulate local activity that has a substantial effect on interstate commerce. The first of these cases was NLRB versus Jones and Laughlin Steel in 1937. The second, United States versus Darby in 1941, and the third was Wickard versus FIlburn in 1942. In 1935, President Roosevelt proposed and Congress enacted the National Labor Relations Act. This law gave the National Labor Relations Board, or NLRB, the power to punish unfair labor practices affecting commerce. In its challenge to the constitutionality of the NLRA, the Jones and Laughlin Steel Corporation argued that the law was, quote, an attempt to regulate all industry, thus invading the reserved powers of states over local concerns. On this question, the court split 5-4. In his opinion for the majority, Chief Justice Hughes acknowledged that the federal government could not regulate, quote, all labor relations, but only what may be deemed to burden or obstruct that commerce, unquote. This test allowed Congress to protect interstate commerce from burdens and obstructions. Chief Justice Hughes wrote that Congress may regulate local activity that has, quote, such a close and substantial relation to interstate commerce that their control is essential or appropriate to protect that commerce from burdens and obstructions.
However, he qualified this holding with a limiting principle. The scope of the power to reach intrastate activity, quote, must be considered in the light of our dual system of government and may not be extended so as to embrace effects upon interstate commerce so indirect and remote that to embrace them in view of our complex society would effectually obliterate the distinction between what is national and what is local and create a completely centralized government. The question is necessarily one of degree.
In the end, the court upheld the NLRA.
In the second case, United States versus Darby, 1941, the Supreme Court unanimously upheld Congress's power to regulate the wages of local lumber workers.
Darby is most famous for introducing the substantial effects test that extended Congress's powers beyond merely protecting commerce from being burdened or obstructed. In overruling Hammer versus Dagenhart, the court held that Congress has the power to regulate, quote, intrastate activities where they have a substantial effect on interstate commerce. As authority for this test, the court relied on McCulloch versus Maryland. Study guide. By relying on McCulloch, the court indicated it was basing its decision on what clause? The Darby court stated that it did not matter if Congress's true motivation was to restrict local activity. The court held that, quote,
whatever their motive and purpose, regulations of commerce which do not infringe some constitutional prohibition are within the plenary power conferred on Congress by the Commerce Clause.
Compare that passage with Chief Justice Marshall's limiting principle in McCulloch versus Maryland. There, he insisted that the court would have a duty to invalidate a law, quote, should Congress, under the pretext of executing its powers, pass laws for the accomplishment of objects not entrusted to the government. Study guide. Can Darby be reconciled with McCulloch's limiting principle? Finally, the court held that the 10th Amendment, quote, states but a truism that all is retained which has not been surrendered. As a result, the police power of the states would no longer figure into identifying the scope or limit of Congress's power. Even after NLRB and Darby, and the near complete control of the court by Roosevelt appointees, the third case, Wickard versus FIlburn in 1942, was considered to be so controversial it was held over for re-argument to the next term. The Department of Agriculture, led by its secretary Claude Wickard, sought to restrict the amount of wheat grown by farmer Roscoe FIlburn, the bulk of which he used on his own farm to feed his livestock. The purpose of the regulation was to keep wheat prices high by restricting the amount of wheat that was grown and sold. We know that at least one member of the court, Justice Robert Jackson, initially favored abandoning all judicial scrutiny of the scope of Congress's commerce power. But even the New Deal court was not prepared to take such a momentous step. Instead, it further expanded the substantial effects test. Even if FIlburn's small amount of locally consumed wheat did not itself have a substantial effect on interstate commerce, when all of the locally consumed wheat nationwide is considered together, in the aggregate, it has a substantial effect on interstate commerce. This doctrine is known as the aggregation principle. After relating evidence on how homegrown wheat used to feed livestock affects national wheat prices, the court held that the fact that FIlburn's, quote, own contribution to the demand for wheat may be trivial by itself is not enough to remove him from the scope of federal regulation, whereas here, his contribution, taken together with that of many others similarly situated, is far from trivial. Study guide. Did the Wickard Court retain any role in constraining Congress's powers under the Necessary and Proper Clause? The Supreme Court would not provide a limiting principle to this expansion of Congress's powers under the Necessary and Proper Clause until the Rehnquist Court.